Thank you, Mr. Chairman, and welcome to all of our witnesses. The majority Republicans call it lawfare when Donald Trump is held to the rule of law and given every right of due process. We call it lawfare when the Trump administration violates the rule of law and tramples the due process rights of Americans, including prosecutors and FBI agents. Mr. Chairman, we have no kings here, no queens, no titles of nobility, no serfs, no slaves. Our revolution overthrew monarchy and the established church. It made our Constitution supreme over the monarchical and oligarchical political ambitions of any man. The 13th and 14th Amendments abolished slavery and gave equal protection to all, royal status to none. But in our time, Donald Trump's crime spree throughout American society has tested the hard-won principle that we are all equal and that no one is above the law. The Supreme Court that Trump has repeatedly bragged about packing and stacking to destroy Roe versus Wade not only brought the curtain down on the freedom and health security of tens of millions of American women trapped in GOP-controlled anti-choice states, it also made the president absolutely immune from prosecution for crimes he commits under the so-called core functions of his office, presumptively immune from prosecution for other so-called official acts, and subject to prosecution only for private, unofficial acts. After more than 2 centuries, this bracing new taxonomy for licensing presidential criminality was announced by the Roberts Court in a 6-3 decision in U.S. versus Trump. It creates presidential exceptionalism, a plainly dangerous doctrine which overturned a unanimous ruling of the D.C. Circuit Court of Appeals. But even that shocking burst of finger painting on the Constitution isn't enough for Trump and his crowd, who seek now complete immunity and impunity from the laws that bind the rest of us. It's not even enough for them to appoint a nationwide crew of embarrassingly servile judges like Aileen Cannon, who may as well be on the bench in Putin's Russia, as she shows little fidelity to the rule of law, but fastidious devotion to the whims of her dear leader. Now they want to pass something called the Pepper Act, to let Trump and his accomplices get their political corruption and election-fixing cases removed from any state court in the land and put in front of far more submissive and pliant Trump appointees in federal court. Donald Trump tried this move in one of his criminal cases, the one in New York City, where he was found guilty of 34 felony criminal counts of falsifying business records to cover up hush money payments he had paid to a mistress before the 2016 election. There, his judge rejected his request to move everything to federal court, saying Trump had failed to meet both the current statutory and constitutional requirements for doing that. As Judge Hellerstein observed in his ruling, the evidence overwhelmingly suggests that the matter was a purely personal item of the president, a cover-up of an embarrassing event. Hush money paid to an adult film star is not related to a president's official acts. It does not reflect in any way the color of the president's official duties. Removal to federal court is reserved for cases where there is an actual federal defense. Let's say the president was tried in Florida state court for assaulting a citizen, but his defense was that the alleged victim was a soldier, and he was just administering fair punishment as commander-in-chief of the army in a time of actual conflict. In that hypothetical case, it would be removed so the federal judiciary could handle the federal question defense. There was plainly no federal question defense in Trump's hush money record falsification scheme. But now, scrambling to appease Trump, an incorrigible recidivist lawbreaker who is looking for a way to disappear all of his state court civil and criminal prosecutions, our colleagues proposed to amend the law so that a president or vice president, or even a former president or vice president, can remove a state civil or criminal prosecution to federal court whenever that case is brought, quote, for or relating to any act while in office, even if that act is of a completely private and personal nature, or where the state court's consideration of the claim or charge may interfere with, hinder, burden, or delay the execution of the duties of the president or vice president. This broad, gaping language would in practice mean that no state court in America could ever conduct a criminal trial of Donald Trump or any other president again, even if the alleged conduct, say hypothetically sexual abuse or criminal fraud, has no relationship to any of his official presidential acts. After all, any litigation can obviously hinder or burden the execution of official duty. It would also permit Trump and his associates to remove the state court criminal cases now pending in Georgia related to the Trump conspiracy to overthrow the 2020 presidential election. This bill is designed to trash basic jurisprudential principles, including federalism, that have served us well since the 18th century. The conceit behind it is the pathetic claim that Donald Trump is just profoundly misunderstood and a victim of the judicial process and a target of unfair prosecutions, although no court has ever once found that. Yes, that Donald Trump, he's the victim, according to our colleagues, the billionaire businessman who's been involved in, check this out, more than 4,000 lawsuits, some in which he is sued as a defendant by, for example, frustrated students at Trump University or ex-mistresses or golf clubs alleging non-payment or plumbers, painters, electricians, and small business contractors alleging failure to pay on their contracts. But most of the ones I could find were ones in which he is the plaintiff, deploying his army of lawyers to sue thousands of people and businesses, including casino patrons, real estate partners, business tenants, and media entities. Most recently, he sued ABC and then CBS for $20 billion. But to hear our friends tell it, Donald Trump is just an Eagle Scout who respects women, would never cook the books, and keeps his hands to himself. The Donald Trump I know about is a civilly adjudicated sexual abuser in New York, a convicted criminal felon, and the only twice impeached president in American history who was most recently impeached in this House for inciting an insurrection against the Constitution, the Congress, and his own vice president. The Senate voted 57-43 to convict him, meaning that although Trump narrowly beat the constitutional spread, robust bipartisan majorities voted that he had indeed incited insurrection against our government. Now look, if you want to see real lawfare, if that's something really in your scopes, then open your eyes to the U.S. Attorney's Office here in the District of Columbia. The pro-January 6 insurrectionist turned U.S. Attorney for D.C., Ed Martin, has fired more than a dozen career prosecutors focused on violent crime from his office simply for doing their jobs, and doing their jobs well. He fired them because they had worked on the January 6 cases which they were assigned to do, prosecuting Proud Boys, Oath Keepers, and other extremists who violently assaulted our police officers, and they were sacked. Just last week, Mr. Martin demoted several other top prosecutors and career supervisors to entry-level positions, again, as retribution for having simply done their jobs in overseeing January 6 prosecutions. That is lawfare. That is a violation of the due process rights as well as the civil service rights of American citizens who did nothing other than obey the law and do their jobs. And this is just the tip of the iceberg when it comes to the administration's attacks on the rule of law. In its first month, from the corrupt quid pro quo in New York City with Mayor Adams, which led to the resignation of multiple Department of Justice lawyers, including the U.S. Attorney for the Southern District, who had been a Justice Scalia clerk and a career-long member of the Federalist Society, and she said she couldn't put up with that, and she decided to quit. Her assistant, another conservative lawyer who had clerked on the Supreme Court for Chief Justice Roberts, and he said you would have to be a fool or a coward to go along with that corrupt bargain between Donald Trump and Mayor Adams. They have halted anti-corruption task forces. They've suspended enforcement of the Foreign Corrupt Practices Act. They have suspended anti-kleptocracy and anti-corruption initiatives, and on and on. If you want to look at lawfare, let's look at what's going on right in front of our eyes today, Mr. Chairman. That's what we should be doing instead of going after some imaginary lawfare by state and local prosecutors who did nothing other than their jobs, enforcing the law in their states, and not a single judge or appeals court or even the Supreme Court under Roberts' court spell has said anything about those people doing anything remotely unethical. I yield back to you.
Gentleman yields back. Chair now recognizes the The chairman of the full committee, Mr. Jordan.
Yeah, I was just going to make a point earlier. One of our Democrat colleagues talked about Kash Patel running the ATF. What I will say is this. When the ATF was run by someone else, I know some of the crazy things that happened. Any of you ever heard of Brian Malinowski? What happened to Mr. Malinowski? They said that he had somehow sold, was accused of selling 6 firearms that he wasn't supposed to sell. Instead of going, and they had a search warrant, instead of going there to Brian Malinowski while he worked, highest paid municipal employee in Little Rock, Arkansas, worked at the Bill and Hillary Clinton Airport. Instead of going to the airport and talking to him, going to his house, and then doing the search warrant, they decided they were going to do a pre-dawn raid. And they were all set to do it on one particular Friday, and then they found out he wasn't home. So they called it off, and they said, we're going to wait till the next Friday when he is home and go at, again, pre-dawn raid. 10 cars pull up, ATF agents and local police. They go up. The first thing you see from the doorbell cam is them putting the tape on the doorbell camera, and then 53 seconds later, Brian Malinowski is shot in the head because he does what any normal person would do. It's why what Mr. Kiley brought up about the crazy law they're proposing in California. He was defending himself. He thought he was getting robbed. Defended himself, gets shot in the head, and dies several hours later. That's the ATF before. So you can criticize Kash Patel. That's ridiculous. Thank goodness he is running the ATF. We don't have the same people who ran it when that happened to Mr. Mountain. Made no sense. 53 seconds. Why not just execute the search warrant like you should? Why not talk to him? Why not pick him up at the airport? Mr. Malinowski, we're going to your house. Call your wife. Let him know where we're coming. We'll go there. We'll execute the search warrant. No, they couldn't do it that way. So I think the good Lord, Kash Patel is running the FBI and, frankly, interim director of the ATF. I don't know if you guys want to, Ms. Miller, you can say something, or Mr. McDermott, I'll let you guys say something if you want, but I thought...
Amen.
Amen. God bless you. I appreciate that. I appreciate that. I'll yield the rest of my... I appreciate you, the witnesses here today. Appreciate the chairman, the good work he does. I yield the rest of my time to the chairman.
Thanks, Mr. Chairman. Mr. Ritter, are knives included in the definition of arms under the Second Amendment?
Certainly, they have been considered arms for millennia. Perhaps man's oldest.
Is there any cases, Supreme Court or other federal cases that shed light on how knives are protected under the Second Amendment?
Certainly, both Heller and Brune bring up the subject of knives as arms, and they are certainly protected by the Second Amendment.
Under the COPA, Knife Owners Protection Act, the purpose of that is allow someone to move from state to state, and while they're actually in transit, they don't have access to their knives. Is that correct?
That is correct.
And so that's why there's been bipartisan support. Generally, they don't have access to those knives, but they also shouldn't be prosecuted for transporting their knives across state lines.
That is correct. I mean, the reason we get bipartisan support is because the bills that we propose are all about criminal justice reform and people not being stopped simply because they're carrying a knife with no criminal intent whatsoever.
And in COPA, there's a provision dealing with private right of action. Why is that so important to the bill?
Private right of action is very important to COPA because COPA is closely related to the Firearms Owners Protection Act. In fact, it was originally based on that. And unfortunately, the Second Circuit in Taraco versus Port Authority determined that those sorts of claims do not give rise to a private right of action. So in some of the states where folks are most in danger of being prosecuted for having an illegal knife, even if they were to follow the lock them up according to COPA, there's a precedent that they have no right of action, and without a right of action, there's very little deterrence for rogue law enforcement or prosecutors to go after them, despite what Congress's intent may be.
Thank you. With that, I'm going to yield it back to Mr. Jordan, who's gone, and so time has expired. And now I recognize the gentleladies from California, Ms. Laurel Lee. I'm sorry, Florida. I'm sorry. What did I say?
California.
Oh, gracious.
Uh-oh.
Understandable mistake, Mr. Chairman.